BC Supreme Court judge has ruled in favor of Edward Rogers in the battle for supremacy at Rogers Communications. The decision ends a weeks-long public battle between Edward, the son of founder Ted Rogers, and the rest of his immediate family. At issue, the company's board of directors.
Edward took his family and the company to court after they ousted him as chair and then deemed the board he created in their absence illegitimate. Today, the judge says Edward keeps control of the company. Joining us now with a legal perspective on the proceedings, the ruling, and what is next is Michael Binetti, managing partner at AGM Lawyers, along with Richard Powers, the National Academic Director at the Rotman School of Management. Thanks to both of you for joining us on this breaking story tonight. Michael, I'll start with you. How unexpected, or maybe expected, was this ruling? It really came down to a meeting or a lack of a meeting and this decision in writing.
I don't think the decision was shocking. I think, frankly, it was to be expected. The BC law permits this very kind of action to be done by signature. And really, it was Rogers' own articles of incorporation that kind of got in the way because they had some notion that a meeting may be required, but ultimately the judge said one wasn't.
So was this the right decision in your legal opinion, Michael?
Well, generally, whoever holds the most voting shares is entitled to make a decision for a company. Whether or not we agree that he should have the most holdings in Rogers voting shares is maybe another issue. But if the family trust has all the shares, and with some very small exceptions where the minority shareholders have to be considered, but generally, yeah, the one who holds the votes gets to call the shots.
Of course, Edward Rogers, the chair of the family-owned trust, he has a lot of sway. Obviously, that's part of the reason that we're talking about this today in the ruling that was out of BC. Richard, should one person in charge of a huge company like Rogers Communications have that much power?
Well, on one hand, I would agree with my colleague. It's certainly not in terms of good governance. I would say no, but in terms of the law. That's why they incorporated in BC, and that's the law there. So until it changes, the whole idea of majority ownership or dual-class shares, whatever you want to call it, is controversial. But you do allow it in Canada, and it allows Edward to do exactly what he did.
So what does Edward Rogers do now, Richard? What are the next steps for him and for the other leaders in this company?
Well, I think it's fairly clear. He wants Joe Natale, the CEO, out as soon as possible. I think that's going to happen, and probably several other members of the management team. So changes will take place, and I think he'll move very quickly before any appeal is, so that it really makes the appeal, in my view. He'll make these changes as soon as possible, and we'll move forward.
Michael, I want to get your opinion on an appeal. We are hearing that one will happen. The success of that is what I want to ask about. But first, I want to ask about what happens going forward, not just with the company and the executives and the change-up that's going to happen there. There is still an incredible family rift that isn't going anywhere. How does this company move forward in the face of such a public family fight?
Well, they have to hope that the business judgment and all of the great support that they have around them kind of informs or gets them over all of the clearly family issues that they're having. Really, this is, it's a multi-billion-dollar business that a lot of Canadians hold stocks in. And they're going to have to get past whatever issues they have because they clearly have them. But legally, there's always a route under the law. You want to appeal, then you can seek leave to appeal, you can seek a stay. There's so many ways that you can get in the way using the courts, but they have to ask themselves whether that makes sense for that company.
Yeah, the judge in this case is not staying the ruling in the face of an appeal, so that will eventually happen, but things sort of carry on in the meantime. What do you think the chances are that an appeal will be successful here, Michael?
This is a very experienced trial judge. She's very well respected. I don't think it was a fluke that they put on such an experienced judge to hear this motion. Her decision is going to be lengthy. She's already declined to stay or put on pause her own decision, which is not shocking that a judge is going to stay their own decision. On appeal, they're going to have to, it's not a new hearing. On appeal, they're going to have to show that she made some error of law or that the decision she made just wasn't open to her. And that's pretty high standard. So I don't know. I'm not so bullish on the chances of an appeal being successful.
Richard, I'm curious for your take on, we talked about the family trust. What about public trust? Look, I don't think anyone's going to be calling up Rogers to cancel their cable tonight, but what should shareholders be feeling, and how do we mend this PR crisis, this PR nightmare that this multi-billion-dollar company is facing?
I think that this does put a little bit to rest into the fact that we have a legitimate board in place now. We'll see what management changes come in the near future. But I think it's all systems go. Edward has a strategy that he wants to deploy. He'll do that. And I think shareholders should feel some comfort in the fact that at least this part of the drama is settled. As far as ongoing disputes in the family, still 3 members of the family are going to be on the board. That's still going to be a bit of a hassle. But again, Edward Rogers controls that board now. So they're going to have to come to some agreement in order to move forward. But I think from a shareholder point of view, this does settle things.
So, Michael, in the face of this, very public legal challenge, it really came down to whether, what Edward Rogers did in the absence of a meeting with his family and with the company. That was really what I don't want to, minimize the role of the judge here, but really that's what it came down to. The family was arguing that there wasn't a meeting and this was just done in writing, and that goes against the wishes of Ted Rogers, that there was sort of this component in place so that didn't happen. Why was that not strong enough, do you think, in the judge's opinion?
Well, I think the judge looked at the law in BC, and the BC law says you at a meeting you can pass what's called an ordinary resolution with 51% of the voting shareholders. But that very same law says, you know what? If you have 2/3 or more of those same voting shareholders, you don't even need a meeting. As long as they're able to vote as if there was a meeting, you can do it in writing. So I don't think the judge really had much of a decision. There was an interesting aspect that the Articles of Incorporation of Rogers kind of mentioned in passing a meeting, but I'm looking forward to her decision. But I don't think I'm guessing that she said that didn't trump what the BC law specifically permits. So this is allowed. Yeah.
And it was. Okay, Michael Binetti, Richard Powers, thanks so much for joining us on this breaking news story on CP24 tonight.
Thank you.